Hi everyone, this is Professor Kiakia, and I just wanted to give you some audio to go along with everything that you have to read in the course. One of the downsides to having online classes, although they're extremely wonderful because they're so flexible and you really can do everything from anywhere that you're located, but one downside is that you do an awful lot of reading and a little bit more self-teaching than you would if you were going onto campus and taking the class there. So what I'm trying to do is incorporate weekly lectures that are audio and visual into the course so that you have an opportunity to hear some of the things that you were actually like reading about and talking about on the discussion board. So bear with me, the video here doesn't always correspond exactly with my voice. It's a tiny little bit of a delay, which can be a little annoying, but I'm going to try my best to keep my eyes focused on the camera and not look down at my notes because I have to peek down to see what the next topic is, so I apologize for doing that. But I really hope that you find the audiovisual lectures to be helpful and a good supplement to everything else that you're reading. I can also hold weekly review sessions if you'd like to hold those. It's a live audio-visual chat. It's located in the classroom. People have found those very helpful in the past, and I'm happy to do that. I find that sometimes I have a lot of students who sign up for it and then they don't show up, so that's kind of difficult as well. I'd like to be able to offer you whatever support that you need. I'm happy to help you in any way that I can. I've given you my cell phone number, and if you need to call me or text me, that's absolutely fine. If I don't answer the phone when you call, please leave a message and I will call you back, but sometimes I'm really busy or I'm in the middle of doing something that I can't stop and put down. If you leave me a text message, I will get that pretty quickly. I usually hear that text go off and I can respond as quickly as I can. The other thing I wanted to tell you, as you get used to the course, you should kind of click around in the classroom and get used to that. One thing you want to use every single week is click on the module button. In the module button, I've put everything that you need to do for that week. So you will see that you have your quiz, you have your lecture notes, you have your PowerPoints, you have all these great things that I've included and found and created for you so that it helps you understand the material that you're reading. But I don't want you to feel at any time that you're out there all by yourself. I'm happy to even talk to you on the phone if you would like live discussion of the material that you're reading. Some of these things are very tough, the concepts. We recently revised this course to help it meet credit hour requirements in order to qualify as a transfer course to a four-year university, and therefore there are a lot of chapters that were added into the course, so it's a challenge to get all of this information talked about and communicated, and on your end studied and learned, and that's a really big endeavor on your part. So please don't feel like you're alone, and if you are hitting a wall in terms of understanding the content at any point in time, I would rather know that and try to help you rather than see you kind of hit a stumbling block and have that reflected on your midterm or your final exam. Okay, last thing I want to mention, I'm kind of a stickler for plagiarism. So please do your best. You'll always grade better if you try it, even if you don't do as well as you think you may. I think it's a normal inclination to read something in a book or online and say, well, I can't say it that way. I can't say it as good as they did. And you're probably right. You know, people who have written these are legal scholars who have studied and written on the topic probably for 30 years. So you're probably right in that. Are you going to get a bad grade though because of that? And the answer is no. If you try your hardest and you put effort in, and I can see that, I will give you credit for that process. You may not earn a perfect grade, but you will do much better if you try yourself rather than copying and pasting from the internet, the textbook, or any other source. Working collaboratively with other students, I can often see that that happens, and that's a really big problem because it deals with academic integrity and dishonesty. Okay, that said, let's talk about some of the concepts for Module 1. And we're talking about chapters, I believe, 2 and 3. So the first chapter deals with jurisdiction, is the major concept that comes to us from chapter 2. What is jurisdiction? It's kind of a weird word. It comes, juris, jury, it's all kind of related. It's a Latin word, and it relates to the law. Jurisdiction is what gives a court the right to make a decision that may affect individuals. So we have three types of jurisdiction normally that we talk about. The first is jurisdiction over the person. We call that personal jurisdiction. We have jurisdiction over the subject matter, and that is subject matter jurisdiction. And we have jurisdiction over property. So can a court require a person to come in and defend a lawsuit? Personal jurisdiction is the issue. We'll have definitely have some issues related to that. I will talk about that in a moment. Then we have jurisdiction over the subject matter. Does this court have the right to make a disposition that affects this subject matter? So if you are filing a civil action, you cannot have a criminal court make a decision on that case. It does not have subject matter jurisdiction. And likewise, a criminal court cannot, a civil court cannot make a decision on a civil case. A civil court can't make a decision on a criminal case. So it works both ways. You've got to be in the right courthouse, and the court has to have the right and the power to make a decision that will affect you over, a decision over your person. The last one I talked about was jurisdiction over property. They call that in rem. Rem is the Latin word that means thing. So it has the right to make a decision over a property or thing. And that is the third type. Now, there are a couple others that you'll read about in your textbook. You'll talk appellate jurisdiction. Is there a question of law in an trial court case that allows the parties to make an appeal and challenge that? That's appellate jurisdiction. We talk about concurrent jurisdiction. We have federal courts and state courts, and they operate at the same time side by side, right? So we have concurrent jurisdiction, and there are some cases that could be filed either in state or in federal court. So that's just another way of saying that. But the main three that we talk about are really subject matter, personal, and in rem. With regard to personal jurisdiction, one of the biggest things that you have to kind of take from that is that a person has to receive notice and an opportunity to be heard in order for due process to be met. We can't just file lawsuits against people, never tell them about that, and then have the court make judgments that will affect them financially and otherwise. So therefore, we have to have some type of a procedure and some types of rules that relate to having notice given to people about lawsuits being filed. That is a matter of personal jurisdiction, so you'll see service of process. Service of process means that the defendant is served with a copy of the complaint and given instructions on what to do with that and how to reply. And that all is regulated by court rules and the rules of civil procedure, 20 days to respond and file a responsive pleading in the courthouses. But with regard to giving notice in order to have personal jurisdiction be effective, that is service of process. Those are your basic concepts with regard to jurisdiction. We will spend some time in the first couple of weeks doing these introductory things and talking about matters that you need to know about that kind of affect all lawsuits, civil in nature. Business law is not criminal in nature for the most part, although there are some business crimes that are committed, and they're quite noticeable. The white-collar crimes are huge. We have pension fraud. We have security scandals all the time, and we have other things that happen. You may have dumping illegally of toxic waste by a company, things of that nature. For the great majority of lawsuits that affect business, though, I would think most of those are civil in nature, and that's where you have a matter of jurisdiction. With regard to criminal law, let's just talk really quickly. In an upcoming module, we will talk about civil and criminal law in more detail, but criminal law deals with obviously crimes against the state. The state is the party to bring the action. In a civil case, the plaintiff would bring an action. In a criminal case, you're usually looking at jail time or significant fines. And in a civil case, usually you have private parties suing for money damages. So there's quite a big difference between the two, but we'll talk about that more in an upcoming unit. Let me talk a little bit about Chapter 3, which deals with litigation. Now, litigation is a word that just refers to having a trial. Many cases, I would think well over, I would say even 95% of all cases actually settle. The parties will go through many of the phases for litigation, but then before the date for trial comes up, you'll have the parties kind of reach a compromise on both ends. We call that process negotiation. You might see that in the section that deals with alternative dispute resolution. Alternative dispute resolution deals with an alternative or a different way of handling a lawsuit or a dispute between parties without having to go through the court system. So we talk about arbitration, we talk about mediation, and things of that nature, mini trials. These are ways to more quickly and more cost effectively handle disputes so that the parties don't have to be kind of hung up for years and years and years. But if we are proceeding to trial, it is not uncommon for this to be a process that takes 3 years or even longer. Sometimes with contract cases, there can be a statute of limitations of 6 years. And what that means is that the parties have up to 6 years to file the complaint. And then from there, it can take even longer to get through the whole discovery phase and get yourself before the court for trial. So the longer the case is in the office, the more expensive it will be. And businesses are aware of this, and that's why they have turned a little bit more towards alternative dispute resolution as a way of resolving disputes. Some businesses will even have an arbitration clause written into their contracts when they create contracts in business. So that will require the parties to mediate or arbitrate in order to resolve disputes rather than going through the costly procedure of going through a trial. But if we were to go to trial, what would happen would be the plaintiff would file a complaint, and it would be served on the defendant with service of process. Right? The summons and the complaint gets served onto the defendant, who then has a statutorily prescribed or a court rule prescribed period of time, about 20 days, to respond and file an answer. So the plaintiff files a complaint, and it's a short and condensed statement of the facts and why they are entitled to relief, and the defendant replies with an answer. And those together, the complaint and the answer, are known as the pleadings. And the pleadings basically give the court the right to oversee the matter and make judgments on behalf of one or both of the parties. After that happens, there is a period of time when certain motions may be filed. Maybe the defendant thinks that there's no merit and may file a motion to dismiss, motion for judgment on the pleadings, different motions that really kind of come right after the complaint is filed. And the court deals with those. We go to court, we argue it out, the court makes a ruling, and then you proceed from there. If the complaint is not dismissed, the parties then go through about a 10-month phase of time called discovery. And discovery really relates to exchanging information back and forth between the parties. The whole point of discovery is so that the trial that eventually will happen is not one that is based on surprise tactics. Oh my gosh, I had no idea that document even existed. If I had known that, maybe I would have settled the case beforehand. None of that. They want a free exchange of information back and forth so parties can kind of prepare their case for trial. So the ending result, the verdict or the judgment, is a result of the merits of the case instead of something else. So we exchange these documents or these answers back and forth. We have written questions to the parties, which are called interrogatories. We have requests for production of documents from each side or each party. Anybody can be deposed, a witness or a party, and by gathering all this information together, most of what happens is a party is able to better assess the merits of their case. So you may say, wow, I have a much stronger case than I thought I did. Wow, look at all this information. Or you may say, wow, I really thought I had a stronger case. I think I better really consider the offer that they sent over last week because I may not really do much better than that. It's a good way to help parties kind of like get a more realistic view of what is going on with their situation. After that happens, after the 10-month period of time, if the parties are not able to resolve their dispute, they will then go back and meet with the judge for a pretrial conference. And at the pretrial conference, the judge is really going to kind of urge the parties to work on getting some type of a resolution and compromise and settle the case. But sometimes you just can't have it. Parties will not, see things the way that they think they should see it, and they just will be very headstrong and proceed to trial. So a trial date will be set. We go to court on the date of trial. At that point in time, you'll have a plaintiff and a defendant and a bunch of witnesses and a bunch of documents. Everybody makes an opening statement. It's just basically, this is what I intend. I think that the evidence will show you to the jury or to the judge, and the other side will present that as well. Then we present witnesses. If I present the witness, it's called a direct examination. And if the other side wants to ask questions of one of my witnesses, they do that by cross-examination. And on cross-examination, you can ask leading questions. You don't have to ask just regular direct questions. You can actually say, isn't it true that on that date you were not wearing your glasses and you need your glasses to see far away? Isn't that correct? And that's a kind of a leading question that you are allowed to ask on cross-examination. So after the plaintiff asks all their questions, then they will rest, and then after the defense does all their questioning, they will rest, and everybody's kind of like rebutted and cross-examine everybody else. Finally, after all that is said and done, we will have closing arguments, where it's the Perry Mason moment in a trial, where you get to say, really make that plea to the judge or to the jury and say, the evidence showed this, and because of that, you have to find this person is liable for breach of contract or whatever it is that you're suing about. After that happens, if there is a jury in the case, the judge will instruct the jury on what the proper law is. And you can see that sometimes that can be really frustrating, because sometimes the law will not coincide with what you think the facts show. So you're bound by the law. If you're a juror, you have to apply the law that the judge instructs you on, and go with that. And some cases like the Trayvon Martin and the Zimmerman case down in Florida, and I know that was a criminal case, but the jurors actually said, we had to go by what the law said, and because the prosecution did not establish what the law required, we could not convict. But there's a lot of debate over that case, and a lot of different cases as well. Once the jury returns a verdict, that is read into the record, and if the judge is the only one, if there is no juror, we call that a bench trial, and the judge alone will make the judgment in the case. And after that, parties may file an appeal. There are post-judgment motions that they can make, like a judgment notwithstanding the verdict, or a motion for a new trial. But if you want to appeal, you actually have to have a question of law. So some type of a mistake made by the judge during the trial would be a basis for an appeal. You can't just appeal because you're not happy with the result. You have to appeal because there is a problem or a question of law. Okay, and after that, the only other thing from the chapter is enforcement of judgment. Can be very frustrating. You can get a judgment in a civil case and still not be able to recover that judgment. So I sue someone, and the jury or the judge finds in my favor, $10,000 verdict, and I can't get a dime from the person. So enforcing the judgment is always the difficult challenge after going through that entire phase. So it's not always a slam dunk, checks in the mail kind of a thing. It's not always the way it works out. Any questions on any of the material from these two chapters, please let me know. I will be posting these weekly podcasts for you. Hopefully they will, just hearing some of it discussed, will make more sense and kind of make it not feel like so much. I understand that reading about the law can be very hard, and it can be very challenging. I will tell you that your textbook is excellent, and it's very good because it is clear, and it's organized, and it's a textbook I've been using for I don't know how long, 10, 12, 15 years, a long time, through many revisions and editions of the textbook. So the cases are short. They're condensed versions of the full cases, which is helpful, so that you have the case to illustrate, but you don't have to read page and page and page and page and page after page. So that's really helpful as well. There are some practice questions at the end of the chapter. You can give those a try. I've given you links to practice quizzes to get you used to the idea of taking quizzes. Your quizzes in class are self-check. That's very helpful, so that you can take those as many times as you want throughout the week in order to get the best grade that you can. And if you think there's an error on the quiz, just send me a message, and I'm always happy to take a look at that. Your midterm exam and your final exam will be a combination of objective questions like you'll have on your weekly quizzes, but you'll also have 3 or 4 essays as well, and you'll have a 3-hour time block to do those tests, and you'll take that online. If you have any questions about the structure of the course or where to find information, please let me know. I use that module buttons, discussions. You'll go to files to find some extra documents. Anything else that's not uploaded into the individual modules, you can find in the files area, and I hope that you click on that when you are doing your scavenger hunt activity. That activity is meant to help you get acquainted with the different parts of the classroom. So that's probably enough for the first module. I will check back in with you on the discussion board, and I hope you all have a great week, and I will talk to you soon.